Judgment in the matter of Goldtrail Travel Limited in liquidation versus Onur Air Tasimacilik.
Lord Wilson will give the judgment to the court.
On the 2nd of August, during the court's vacation, we issued our judgments on this appeal. There was then no opportunity for us to explain our decision in the usual way. On behalf of the court, I do so now. The dispute is between a British travel company, now in liquidation, and a Turkish airline. A judge ordered the airline to pay damages of over £3 million to the travel company, and the airline wants to appeal to the Court of Appeal, which has granted it permission to do so, but has exercised its power to attach a condition to the grant. The condition is that the airline should pay into court the entire disputed sum of damages awarded against it, so that, were the appeal ultimately to be dismissed, the money would be there for the travel company to take. The appeal to us has arisen out of an application made by the airline to the Court of Appeal for discharge of the condition for the payment into court. On 21st January 2016, Lord Justice Patten refused to discharge the condition, and the airline's appeal to us has been against his refusal to do so. The basis of the airline's application to him was that it couldn't afford to make the payment into court, with the result that the condition would prevent it from continuing with the appeal, even though the court has seen fit to grant permission for it to be brought. Such a result is usually described as the stifling of an appeal, and we've made clear in our judgments that where an appellant establishes that a condition would probably stifle the appeal, it shouldn't be attached. A particular difficulty arises when the appellant is a company which on the face of it has slender resources, but which is owned or controlled by someone with ample resources. Can the court take his resources into account when deciding whether the condition would stifle the company's appeal? This difficulty arose in the present case. The travel company argued to Lord Justice Patten that the airline had a wealthy owner who had lent large sums to it, who directed its operations, and who could easily afford to enable the airline to make the payment into court. In its judgments on this appeal, this court has held that unfortunately the Court of Appeal's approach to this sort of argument fell into error some years ago. For the approach developed by the Court of Appeal and loyally adopted by Lord Justice Patten was that in exceptional circumstances it could reject a complaint that the condition would stifle a company's appeal if it was owned or controlled by someone who could advance the necessary funds to it. We've now held that this approach is unprincipled. It is the financial position of the appellant company, including its ability to borrow, which is alone relevant. And so the question is not whether its owner or controller could advance the necessary funds to it, but whether he probably would do so. A majority of us has proceeded to conclude that the airline's appeal should be allowed and that its application should be remitted to Lord Justice Patten for redetermination by reference to the correct criterion. The minority, however, has considered that even by reference to the correct criterion, the airline's evidence fails to establish that the condition would stifle its appeal to the Court of Appeal, and so it would have dismissed the appeal to us here.